You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Well, hello, everyone. Thank you so much for tuning in. My name is Wang. I'm special counsel in the election law practice at Wiley. And I'm joined today by my colleague, Joan Stewart, who is of counsel in our telecom, media, and technology, or TMT practice. This is our second podcast in a series on H.R. 1. H.R. 1 is the bill that Democrats have introduced in the House and Senate, which would enact major changes to the federal election campaign finance and lobbying laws. So in this segment of our podcast series, we will focus specifically on the H.R. 1 provisions that regulate digital political ads, which include both campaign and issue ads, and also how the bill would affect both the purchasers of such ads as well as the sellers of ads. And also, we'll discuss how all ad platforms, regardless of the type of media, will be required under the bill, if it passes, to take measures to prevent foreign nationals from purchasing political ads.
Thank you, Eric. Thank you for asking me to join you today. So let's start with a discussion of how this bill will expand the regulations that apply to digital political advertising. So with consumers of entertainment, news content, and social interactions increasingly moving to online and digital platforms, campaign and issue advertisers are following this movement online. So how is H.R. 1 going to address online political advertising?
So let me start with the basic regulatory framework under the existing law and then discuss how H.R. 1 would change the existing law. So under the existing federal campaign finance framework, there's an array of reporting and disclaimer requirements that apply if content is subject to regulation. And so H.R. 1 would expand those reporting and disclaimer requirements as well, which we discussed in our first H.R. 1 podcast segment, and which I'll also discuss a little bit more later in this segment. In 2006, the Federal Election Commission issued what's called its Internet rulemaking, sometimes known as the Internet exemption. And under that 2006 rulemaking, I'll quote from the regulatory language, only communications that are placed for a fee on another person's website will fall within the ambit of the federal campaign finance law. So the FEC's main concerns in enacting that rulemaking at the time were to protect bloggers and also to exempt the costs associated with an organization maintaining its own website from being subject to regulation under the federal campaign finance law. And those concerns might seem sort of quaint now, but also with the emergence of social media, the 2006 rulemaking also exempted, as it turned out, unpaid Facebook posts, tweets, unpaid YouTube video uploads, and similar types of unpaid content. Moreover, I'll point out that despite the outdated terminology in the rulemaking to websites specifically, it's generally understood that the federal campaign finance laws do apply to not only paid banner ads, but also to paid ads that are run in digital apps, such as smartphone apps, social media content that's promoted for a fee, search engine results that are promoted for a fee, as well as paid ads in streaming video and audio content. So those types of paid advertising, digital advertising, are actually all regulated under the pre-existing law and the FEC regulations. But H.R. 1 would supersede the FEC's Internet rulemaking and the agency's historical precedents and the guidance that it's issued that have applied the rule over the past 15 years and that many of us have become familiar with. And instead, H.R. 1 would replace that regulatory standard with a new regulatory standard, which specifically would cover any quote unquote paid internet or paid digital communication. That's the specific regulatory standard that's used in the bill. So it's not exactly clear what that language means. And I think some ambiguity will arise principally with respect to organizations' own websites, as well as unpaid social media posts that have production costs. So with respect to organizations' websites, for example, which are, as I mentioned before, are currently exempt under the FEC's rule, organizations' websites typically nonetheless still do involve some costs, such as costs for server hosting, domain name registration, website design and maintenance costs. So under the new HR1 regulatory standard of any paid internet or paid digital communication, do such costs nonetheless now have to be subject to regulation under the federal campaign finance law. Another concern that's come up repeatedly before the FEC has been political and issue advocacy organizations that use paid staff or consultants to create and post unpaid content. So, many videos are uploaded, of course, at no cost on YouTube, Vimeo, or TikTok, or other similar platforms. And even though they're uploaded at no cost, they have underlying production costs that sometimes can be quite high. So again, even though these are not regulated under the existing FEC rule, will those costs nonetheless be now subject to regulation under the new HR regulatory standard of any paid internet or paid digital communication? And so we just don't know yet. Another specific regulatory standard that HR1 would change is the so-called electioneering communications under the existing law. Under the existing law, an electioneering communication is defined in terms of a broadcast, cable, or satellite ad. So, right off the bat, that definition does not include digital ads, internet ads. And electioneering communications under the existing law have to refer to a federal candidate within 60 days before a general election or 30 days before a primary election. And moreover, they have to be targeted to at least 50,000 voters within the candidate who's identified within that candidate's jurisdiction. HR1 would expand the regulation of electioneering communications now to include all digital ads that refer to a federal candidate within those time windows that I just mentioned, that are placed on certain large online platforms. What's strange about HR1 is that unlike for these other types of electioneering communications, which in order to be regulated have to be targeted to at least 50,000 recipients within a candidate's district, as I just mentioned, for digital ads, HR1 would not have any targeting requirement whatsoever. So a digital electioneering communication, so-called electioneering communication that refers to, House Speaker Nancy Pelosi, for example, or Senate Leader Chuck Schumer, if that digital ad is only disseminated in Florida, for example, even though that digital ad is not targeted at Nancy Pelosi's district or Chuck Schumer's state, it would nonetheless be subject to regulation ostensibly under HR1 if it were to be run within 30 days before either of those members of Congress's primaries or 60 days before their general election. And that's especially odd because with digital ads, it's possible to target these ads with quite a lot of precision. And so this concept of targeted to the relevant jurisdiction under the existing electioneering communications law could easily be applied to digital ads, and yet HR1 does not apply that concept to digital ads. Speaking of ads on online platforms, HR1 also would mark a significant departure from the existing law by imposing some new requirements for online platforms themselves, similar to the public file requirements for political and issue ads that currently apply to broadcasters and cable and satellite operators. And so, Joan, could you tell us a little bit more about those public file requirements that HR1 would impose?
Yeah, the new public file requirements are sweeping. So they would impose a public file requirement on online platforms, which is broadly defined to include public-facing websites, web apps, digital apps that have 50 million or more unique monthly visitors. So, for example, a TV station's website or mobile app, a social network, the website of an advocacy organization, or an OTT platform could be subject to these requirements if they receive enough unique hits per month. Operators of these online platforms would have to maintain records for any advertiser that purchased qualified political ads of more than $500 annually. So with such a low monetary threshold here, the public file requirement is likely to be triggered pretty quickly for most advertisers. And so the definition of qualified political ads tracks pretty closely to the type of ads that broadcast cable and satellite carriers must currently document in their online public file pursuant to the Federal Communication Commission rules. So these include ads purchased by a candidate or messages that relate to a political matter of national importance, which de facto includes ads relating to federal candidates, elections for federal office, or national legislative issues of public importance. But the information that must be placed in the public file under HR 1 goes significantly beyond which is currently required of broadcasters, cable, or satellite providers. So the public file rule for online qualified political ads would require the following material be maintained online: a digital copy of the ad, a description of the audience targeted by the ad, the number of views generated, the date and times the ad was first and last displayed, the average rate charged for the ad, the name of and the office sought by the candidate referenced in the ad, or identification of the national legislative issue of public importance that was discussed in the ad. If the ad sponsor is not a candidate or their campaign committee, then you need to include the name of the sponsor, as well as the name, address, and phone number of a contact person for the sponsor, and a list of the chief executive officers and board members of the sponsor. This material must be made available online as soon as possible, and that concept is not defined and has been hotly debated at the FCC as to what that means, and retained for 4 years. So failure to provide or collect this information triggers liability for both the advertiser as well as the platform, and the liability here could number several thousands of dollars per violation. So these will be pretty significant requirements if this bill is adopted. Eric, let's turn to the disclaimer requirements proposed by this bill. So in addition to the information that online platforms are required to make available for political and issue ads, HR 1 would also require certain information to be displayed on the face of digital political ads in the form of disclaimers. So first, who's responsible for including the required information?
Sure, Joan. So unlike the public file requirements that you just discussed, which under HR 1, both the advertiser as well as the advertising platform would be responsible for complying with, the FEC, the Federal Election Commission, has always taken the position that advertisers and not the advertising platforms or media companies are responsible for including any disclaimers that are required under the campaign finance laws, even though that's not explicitly clear under the statute. But it doesn't appear that HR 1 would change the existing law in this respect. Under HR 1, it seems like advertisers would continue to be responsible for displaying any required disclaimers. Nonetheless, I do think that digital ad platforms and media companies that have digital advertising programs should be aware of how HR 1 would expand these disclaimer requirements for their political advertisers, because in some cases, these disclaimer requirements may make certain popular ad formats that media companies offer difficult for political ads. And so I think they should be aware of that.
And so what are the specific disclaimer requirements under HR 1?
Sure. So generally speaking, HR 1 would expand the extensiveness of several of the existing FEC disclaimer requirements for digital ads. And I think it's worth pointing out, first of all, that digital ads are currently subject to some baseline level of FEC disclaimer requirements, even though there's a common misconception out there that I think that the internet is sort of a wild west and that disclaimers aren't required on digital ads currently, and that's not the case. Even though in practice, I think some advertisers have sort of ignored the requirement for their digital ads at their peril. But nonetheless, under the existing law, as I mentioned before regarding the 2006 FEC internet rulemaking, digital ads, if they're subject to regulation, then they have to, at a minimum, include some sort of paid-for-by identifier, identifying the sponsor that's responsible for sponsoring the ad. Sorry to be a little bit repetitive there. But there also might have to be some additional information in the disclaimer, depending on the type of the advertiser or the nature of the ad. But HR 1 would also require digital ads to include a so-called stand by your ad component for the disclaimer. And a lot of Americans are familiar from watching TV or listening to radio campaign ads. Stand by your ad component is part of the disclaimer where the candidate has to either appear on screen or do a voiceover in a audio ad and say, I'm so-and-so candidate for this office and I approve this message. And so HR 1 would add that requirement also to digital ads, which currently aren't subject to that additional disclaimer requirement. And then HR 1 also would subject ads that are run by entities other than candidate committees to include some comparable stand by your ad disclaimer component as well, which would have to be delivered in person by the head of the organization. Moreover, in some cases under HR 1, the disclaimers also might have to identify a sponsor's top donors in the disclaimer if the sponsoring organization is donor funded. And we discussed that in a little bit more detail in our first HR 1 podcast. So the existing FEC disclaimers can already be quite lengthy. In an advisory opinion request that we filed with the FEC on behalf of a client a number of years ago, we established that those existing disclaimers for audio ads can take up to 10 to 15 seconds. And some video disclaimers under the existing law also have to be displayed for at least 4 seconds. And as I mentioned just now, HR 1 would add additional requirements to those existing disclaimers. So HR 1 would make the disclaimers even longer in many cases. The problem, especially with digital ads, is that a lot of the audio and video, so-called pre-roll or mid-roll ads that are available from digital platforms are only 10 to 15 seconds long total. So, and some are even shorter. So to include an FEC disclaimer basically would eat up the entire amount of the ad that's permitted under those digital ad formats. Now, HR 1 does acknowledge this to some extent, and HR 1 would permit alternative mechanisms for displaying the full disclaimer if the disclaimer proves to be too unwieldy for a particular digital ad format. Nonetheless, at a minimum, under HR 1, the name of the ad sponsor still must be identified in the ad itself. And then some means must be provided for a viewer or a listener to obtain the rest of the disclaimer. For example, through a click-through mechanism in the ad, a hover-over mechanism, or a hyperlink in the ad. So digital ad platforms should be prepared to offer advertisers ways to meet these alternative disclaimer requirements if they wish to continue selling ads to political advertisers should HR 1 become law. Speaking of things that advertising platforms should be preparing for if HR 1 were to be enacted into law, there's another requirement in the bill for media companies with respect to foreign nationals purchasing political ads. So can you tell us a little bit more about that provision, Joan?
Sure. So to enforce its goal of preventing foreign interference in U.S. elections, the proposed law explicitly makes broadcast stations, cable, satellite, and online platforms responsible for policing the provenance of political advertising. So I just want to be clear here, this portion of the law is going to apply to broadcast spots as well as online advertising. So broadcast, cable, satellite, and online platforms under this new obligation could be held liable if they fail to make quote unquote reasonable efforts to ensure that campaign-related disbursements are not purchased either directly or indirectly by foreign nationals. For those of you looking for more information on what qualifies for a campaign-related disbursement, please download our first HR 1 podcast where this was discussed in detail. But let's talk more about what is a reasonable effort, which unfortunately is really not well defined in the proposed bill or in the bill. So the simplest way to qualify with a reasonable effort obligation would be to accept payment from credit cards with a U.S. billing address. The regulation proposes that it is reasonable to accept that the origin of the payment is from the U.S. when the credit card billing address is a U.S. address. However, the law provides little guidance as to what would be considered reasonable efforts when payment is not made by credit card. other than to note that the platform would not be considered to have made reasonable efforts unless they ask the advertiser explicitly whether the advertiser is a foreign national. They don't really provide any guidance as to whether you can accept what they tell you or whether you need to do additional research. But I think our takeaway on this is that unlike the rules that currently apply to broadcast stations, satellite and cable companies, HR 1 may require these entities to do independent research into the advertiser before accepting the ad buy, which is a significant departure from current obligations.
Well, thank you so much, Joan. So as I mentioned at the beginning, HR 1 is a massive bill. It's nearly 800 pages. And even for the relatively narrow issues that we just discussed, specifically digital political ads and media companies' liability for policing foreign nationals' purchase of political ads, there's a large number of interrelated provisions that are just scattered throughout various sections of the bill text. And we barely scratched the surface of the bill, even with these two podcast segments on HR 1. So if you're interested more in the bill, please stay tuned for additional podcasts from us on HR 1, which may address other issues such as changes to the federal lobbying laws and also restructuring of the Federal Election Commission. Of course, if your organization has any questions or concerns about HR 1, please feel free to reach out to us. Again, my name is Eric Wang, and my colleague here was Joan Stewart. And you can find our contact information on our website at www.wiley.law. Thank you so much for tuning in.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.